Good morning. I am Dr. Harpreet Kaur. I am Professor of Law at National Law University, Delhi. Today I will be discussing the last module on the course of competition law. This module is module number 24 and we will discuss contemporary issues in competition law. So, when we say contemporary issues in competition law, the objectives of this course outline is that we will discuss and know about the recent developments in competition law in India. We also know that Competition Commission has completed its 5 years of inception. So, we will also discuss what have been the cases which have been discussed by the Competition Commission, and also we will try to understand the issues of concerns for Competition Commission of India. We will also assess the role which has been played so far by the Commission in competition advocacy, and we will also find out the sectors where the competition interface has so far reached. We know that Competition Act was enacted in 2002, but its full enforcement was delayed, and it was only in 2009 that the Competition Commission was fully became functional. So far in 5 years, the sectors which have been covered by CCI, they include stock exchanges, travel, infrastructure, real estate, automobile, pharmaceuticals, mining, manufacturing, entertainment and financial sectors. And the Commission has imposed penalties for more than 80 billion in 5 years, 80 billion rupees in 5 years since its enforcement, and the Commission has received more than 150 filings for approval of combinations. It has also drafted certain regulations for its good functioning, and the effectiveness of the act is obviously is good when the regulations are also framed. So, the regulations which are framed by CCI include the general regulations, determination of cost of production, lesser penalty, manner of recovery of monetary penalty, meeting for transactions of business, and procedure in regard to transaction of business regulations. So far CCI has undertaken 461 cases. This number is given by the website of CCI, and this was till 31st March 2014. 461 cases were taken up by CCI, out of which 380 cases were through the information which was filed under section 19(1)(a), and 16 cases were suo motu taken up by CCI. Let us now discuss some recent decisions by CCI. So, I will start with the cases from 2012 onwards and will come to 2014. The first case which I would like to discuss is the case of Coal India Limited versus suppliers of explosives. In this case, the Coal India Limited has filed information with CCI about alleged cartelization of the manufacturers of explosives, and CCI had conducted the inquiry, and these manufacturers, they were found engaged in boycotting e-reverse auction, and so they were held guilty under section 3 subsection 3b and subsection 3d. So, we know that section 3 deals with anti-competitive agreements, and subsection 3 is presumption of anti-competitive agreement, and section 3b is about restrictions or limitation on the output or market or supplier of the products or the provision of services, and D is about bid rigging. So, over here there was a boycott, joint boycott by all the manufacturers of explosives of e-reverse auction, which was given by the Coal India Limited. The second case is of Varka Druggist and Chemists, and other party was Chemists and Druggist Association of Goa. This was again decided in 2012, and complaint was filed by the Varka Druggist and Chemists that the association has been engaged in restrictive trade practices, and the case was transferred to CCI from MRTPC because the case was originally filed in Monopolies and Restrictive Trade Practices Commission, and from there the case was transferred to CCI, and CCI came to the conclusion that the conduct and the practices which are adopted by association, they were limiting and they controlled the supply of drugs in the district of Baroda. So, they were found guilty under the section 3(3)b, and the association was fined by CCI. In the case of LPG gas cylinders, again a 2012 case, a suo motu action was taken by CCI against the manufacturers of LPG gas cylinders, when a tender was floated by Indian Oil Corporation for supply of LPG cylinders, and they were found to be the gas cylinder providers, they were found to be engaged in the bid rigging, and these manufacturers, they had manipulated the bids in order to quote identical rates in the bids, and all of them, they were found guilty of engaging in anti-competitive practices under subsection 3, and all of them, they were equally found to be in contravention, and they were held liable to pay a penalty of 7% on the average turnover of their companies, and no mitigating circumstances were found by CCI in this case. Next is tire cartelization case. In this, All India Tire Dealers Association had filed a complaint with CCI. They alleged that the association alleged that the major tire manufacturers in the country, they were engaged in price fixing and restrictions on the production and supply. So, so the CCI investigated into it. The inquiry was done, although there were certain indications of cartelization, but no substantive evidence was of any existing cartel was found. So, the Tires Dealers Association went into appeal against CCI to Competition Appellate Tribunal, but their appeal was dismissed by the COMPAT. In case of cement cartelization case, which is a very well known case, the Builders Association of India, they had filed an information with CCI against Cement Manufacturing Association and 11 cement manufacturing companies for their alleged involvement into monopolistic and restrictive trade practices, and the commission found that their practices were in contravention of section 33A and section 33B because they were directly or indirectly, they were fixing the prices, and also they were limiting the production and supply of cement, and the production was below the capacity of the individual cement manufacturing companies. So, there was a clear contravention of both the sections over here. So, the penalty was imposed on the net profit for the years 2009, 2010 and 2010 to 2011, and this penalty was 0.5% of the net profits against each cement manufacturer, and cease and desist order was also passed by CCI against them, so that they should not be further indulged into such kind of anti-competitive agreements. And this penalty was found to be excessive by the cement manufacturers. So, they went into appeal against this in COMPAT, and COMPAT said that first of all you have to deposit 10% of the penalty amount before the hearing, and then companies, they went to Supreme Court, and Supreme Court directed them to abide by the decision of the or the order of the COMPAT or the Appellate Tribunal on Competition Matters in 2013. Next is Board for Cricket Control in India. Over here also the commission found that BCCI was adopting practices which were leading to denial of access to markets, and it was found to be held guilty in contravention of section 2 subsection 2C. So, there it was abuse of dominant position and denial of access to market. So, Competition Commission passed a cease and desist order over here that they should not exercise any practice or adopt any practice which denies market access to potential customers, and penalty at the rate of 6% average annual revenue for the last 3 years was imposed. In the case of aluminum phosphide tablets manufacturers, a suo motu case was taken up by the CCI. In this case, the information was provided by Food Corporation of India, and this was that they have faced an increase in the production in the cost of procurement of, because Food Corporation of India procures these tablets for the preservation of the food grains. So, they said that there has been increase in the cost of protection of the procurement of due to the agreement between the aluminum phosphide tablet manufacturers, and the commission found them to be in contravention of section 3, 3B and 3D, and a penalty of at the rate of 9% of average turnover of 3 manufacturers on the 3 manufacturers was imposed. In the case of Micromax, the commission had received a complaint from Micromax that Ericsson was indulged in unfair trade practices by demanding unfair, discriminatory and exorbitant royalty for its GSM technology related patents. The allegation prima facie was found to be true, and the practices adopted by Ericsson were discriminatory and contrary to fair, reasonable and non-discriminatory terms. In the next case, a reference was filed by Directorate of Drugs, Director of West Bengal with CCI, where it was alleged that anti-competitive circulars were issued by Bengal Chemist and Druggist Association, and under these circulars retailers were not directed, they were directed that they should not offer any discount to consumers, and CCI had done the investigation, and it was found that they were, their zonal associations as well as district committees, they were indulged in directly or indirectly in determining the sale prices of the drugs and medicines, and they controlled or limited the supply of the drugs and medicines. So, a penalty of around 18 crores was imposed on the association. In another case, DLF Universal Limited, which is a subsidiary of DLF Limited, CCI had found a prima facie case for investigation. The informant over here, he said that his family had booked 5 units of commercial office space in DLF Corporate Greens project in Gurgaon, and commercial office space buyers agreement was signed between the parties, and as per the agreement the possession was supposed to be handed over between June 2011 to September 2011. The informant over here alleged that DLF had been in abusive position, and he has been abusing its dominant position, as the agreement which the buyers had to sign, they were the agreement was unilateral, one-sided and unfair. And then the commission also looked into the agreement, and they found that it had clauses where the builder can modify or later on modify the agreement later on without the consent of the buyers, and he can unilaterally abandon the project without giving any reason to the buyers, with liability to refund money at 9% of simple interest. The buyers were required to pay interest between 15% to 18% on delayed payment of installments, and there was no provision for adequate compensation to buyers in case of delayed possession. So, the matter has been referred by the Commission to Director General for investigation. So, over here we can see that the difference in the interest rate which the DLF has to pay and the interest rate which the buyers they have to pay, there is quite a lot difference in these two interest rates. Another development is about involving merger of Sun Pharma and Ranbaxy, where we know that Daiichi Sankyo had a share in Ranbaxy, and that share they were selling to Sun Pharma. So, in this case the Sun Pharma is becoming India's largest pharmaceutical company and about world's 5th largest specialty generic drug manufacturer, and so this the merger petition, merger information was filed by CCI. So, a little later we will discuss about the latest position which is going on in this case, because it is still under approval of CCI. Then CCI also fined Google for an amount of 1 crore for its failure to cooperate in an ongoing investigation, and Director General of Competition is still investigating abuse of dominant position by the Google in online search and search advertising. Now, these have been the recent decisions which have been undertaken by CCI. Now, let us understand what are the issues relating to competition in our country. We have not been able to adopt the competition policy of 2011. We know that once we have a competition policy which is a part of the larger policy framework of the country, only on the basis of that the competition law can formulate its regulations and it can work properly. So, there has been a need that and it was that this every 5 years or so this competition policy has to be reworked, and in case of the National Competition Policy of 2011, which is in the draft form, it is written that the aim of the competition policy is to create a framework of policies and regulations that will inform other policies to facilitate competitive outcomes in the market. The competition policy is a critical component of any overall economic policy framework. Competition policy is intended to promote efficiency and to maximize consumer or social welfare. It also promotes creation of a business environment which improves static and dynamic efficiencies, leads to efficient resource allocation and consumer welfare, and in which abuse of market power is prevented or curbed. It also promotes good governance by restricting rent seeking practices of economic actors. So, this paragraph indicates that what is the importance of competition policy. So, this is the high time that we should adopt the new competition policy. The major challenges which are faced by the Competition Commission, they include the enforcement of competition law against the state owned enterprises, public procurement and creation of competition culture. To a certain extent, the problem which was faced by Competition Commission against enforcement of this law by against SOEs, this has been taken over by the Competition Commission, and now we have understood the case of we have looked at the case of Coal India Limited also. So now all state owned enterprises, they are also now within the purview of the Competition Commission's jurisdiction, and we know that sovereign functions where the department of a government is involved into sovereign functions, over there Competition Commission will not have any jurisdiction. Yes, there are issues of public procurement, that there have been number of instances of bid rigging in the case of public procurement, and creation of competition culture is still a challenge for the Competition Commission, because although they are insisting on their competition advocacy, they are trying to have information circulated to all the required participants, but still there is a need for creating a culture of competition. The Competition Commission has been insisting on the competition compliance program. It says that every company should have a proper competition compliance program, because otherwise the companies may have contravention of the compliance, and which may lead to any sort of penalties which can be imposed by the Commission under the Competition Act of 2002, like there can be heavy fines can be imposed, and compensation can be given, cease and desist order can be passed against the companies, or the dominant undertakings can be split up by the companies, or any type of agreement which is made by the company can be modified by the company. So it is better for the companies to have a competition compliance program, and there should be one compliance officer who should be in charge of this compliance. Imposition of heavy fines has been in controversy last few years, since the Commission has started putting up the heavy fines. One group of persons, they say that it is good that the Commission is fining it very heavily, because otherwise it will not lead to any deterrence on the companies, and they will indulge into contravention of the Competition Act. The other group says that any kind of heavy fine will never lead to any deterrence on the companies, because even otherwise they will find other ways of contravening the act. So this is a controversy which is going on, that whether there should be heavy fines imposed by the Commission or not. Another issue is about interface between the Competition Commission with other sectoral regulators. There are certain sectoral regulators who do not want any kind of interference of the Competition Commission, but over here one has to see that Commission has a broader role, and its role is to check into to bring and promote fair competition in the market, whereas other sectoral regulators, they have their own specific targets which are given to them, or specific works which have been assigned to them. So whereas let us take example of banking merger of banking companies. It has been decided that Competition Commission will have no jurisdiction over the banking mergers, but when it will come to the anti-competitive practices, then or the price related practices, then the Commission will have the jurisdiction to view these mergers also. So one has to see that interface is there, but the purview of, or the jurisdiction of the Commission, or the work which has been given to the Commission is entirely different. It has to look into the market players, whereas other sectoral regulators, they do not look into the market players. Let us now discuss about the FDI policy of Government of India. We know that as per the FDI, government wants foreign direct investment up to 100% in few sectors, and especially in insurance sector, it is insisting that we should have 49% of FDI in insurance sector. Now these FDI can be only in the form of acquisitions, or in the form of joint ventures. So there is a possibility, high possibility, that anti-competitive issues will arise over here, because the remaining enterprise or the group or any enterprise after acquisition can meet the threshold limit, and there will be a chance that if it meets the threshold limit, then the approval of the CCI will be required over here. So we see that as per the policy of FDI, the issues relating to competition will increase in number, and there is also possibility of abuse of dominance and likelihood of adverse effect on the competition under these issues. Now CCI has filed, has made Memorandum of Associations with European Union and US antitrust authorities for cooperation, because under section 32 it has extraterritorial jurisdiction, that where any arrangement or any kind of combination or merger or agreement, if it is done outside India, but it has effect on the inside India, on the market inside India, then the jurisdiction can be then the Competition Commission will have the same jurisdiction as it has for the practices within the country. So for this purpose, certain Memorandum of Associations have to be made between the countries. So these Memorandum of Associations has been made by CCI with the European Union and US antitrust authorities. Now the capacity building of Competition Commission has been a major challenge with the Commission, although the Commission is trying to have people, train people who will be well versed with the competition issues, and especially the economic issues of economics part of the competition problems or issues. So it is working on the capacity building, but this is still a challenge faced by the Competition Commission. The Competition Amendment Bill was proposed in 2012, but it has not been so far passed by the Parliament, and there are certain modifications which have been proposed by the bill. There is a requirement of more research in areas, for example, on the sectoral interface, the new sectors which are coming up, because now, for example, in the insurance sector, Competition Commission has not been able to take to do anything for insurance sector. So the interface between insurance sector, because now if FDI up to 49% will be there in the insurance sector, the competitive issues will arise over there. Then interface between IPRs, we all know about the patent related cases that have been going on. So further research is required. Economic aspects of competition law, that is another area where we need people and where we need good research, and also there is a need for researching on the procedural fairness, because everywhere when it comes to the natural justice and when it comes to the decision by the by any of the regulatory authorities, the procedural fairness is an area which is always in controversy. So research is required that how a commission can improve upon that its procedure, so that it is following the principles of natural justice and it is procedurally fair. If we look into the record of the filings before the commission, we see that the number of complaints which were received and investigated by the Competition Commission in 2010 to 2011, it had received 82 complaints, and in 2010 to 11 it received 99 complaints, 147 complaints in 2012-13 and 114 complaints in 2013 and 14, and major so we can see that there has been reduction in number of the complaints which are filed. The major reason can be that there has been a lack of awareness about the competition law in small towns. So maybe the competition advocacy has to be little strong, and the commission should also bring it to the knowledge of the market players that it is not against the market players, but it is trying to promote fair competition, bring fair competition in the market, but it is not working against any of the market players or the company. And it also should also promote and inform the participants in the market or the market players that it is having a leniency program. So leniency program is a very good incentive for the companies, and if they want to inform the commission, they will be given proper leniency under this, some exemptions will be given to them. So these are this is some information about the Competition Commission and its the cases which have been taken up by the commission. There are latest decisions which I will be now dealing with, like in recently CCI has approved the proposed joint venture between 3 Japanese entities, Fujitsu, Panasonic and Development Bank of Japan. And Development Bank of Japan, which is owned by the government of Japan, it does not have any operations in India, whereas rest of the 2 companies, they have their presence in India, and the commission could not find anything anti-competitive. So no such concern was found by the commission, and this proposed joint venture will specialize in system large scale integration design and development of certain logic integrated circuit products. So an agreement was made between these three entities in early 2014, and a financing agreement is also executed between them. So this is the recent approval which has been given by the CCI. Then it has also approved Adani Power's 6,000 crore purchase of Lanco Infratech's 1200 megawatt thermal plant in Udupi, Karnataka, and no monopolizing market share was found by Competition Commission here, and it was held by the Commission that post combination the combined market share of the acquirer, both in terms of the installed capacity and electricity generation, it would not be significant enough to raise any competition concern. Next case is the CCI's order against Indian Jute Mills Association and Gunny Trade Association. So an information was jointly filed by Indian Sugar Mills Association, National Federation of Cooperative Sugar Factories Limited, and All India Flat Tape Manufacturers Association. They alleged that anti-competitive agreement has been signed by the members of Indian Jute Mills Association and Gunny Trade Association in fixation of sale prices of jute packaging material by issuing daily price bulletin. This bulletin was issued by Gunny Trade Association, and obviously it was issued for the pricing of jute bags for the members of IGMA and GTA, which they had to follow. So the commission was able to find that yes, the price was fixed by IGMA and GTA. So the commission imposed a penalty of rupees 7.68 lakhs and rupees 35.16 thousands at the rate of 5% of the average turnover of the last 3 financial years on Indian Jute Mills Association and Gunny Trade Association respectively, because they had contravened the provisions of section 3 of the Competition Act. Let us now discuss the case of Sun Pharma and Ranbaxy, the deal, the merger deal over here. This deal is about $4 billion, and this deal was informed to be signed in April 2014, and over here the latest information about this is that on August 28 the company had received from CCI an instruction or an order that they order was given under section 29 subsection 2 that the proposed details of the proposed deal, they should be published for the public information. Now over here if we go by the opinion which is given, the statement which is given by the company, that company has received a direction wide letter dated August 27, 2014 under section 29 subsection 2 of the Competition Act 2002 from the Competition Commission of India, directing the company to publish the details of the proposed combination in the prescribed format within 10 working days from the date of the said letter of the CCI. And in a similar filing, the Sun Pharma has also informed the stock exchanges that they are in the receipt of direction under section 29 subsection 2 of the Competition Act from the CCI, directing the Sun Pharma to publish the details of the proposed combination within 10 working days from the August 27, 2014 in form 4 contained in schedule 2 of the combination regulations. So these are the forms which are given under combination regulations. Now under this section the power of the CCI is that if the CCI is of prima facie opinion that the combination has or is likely to have an appreciable adverse effect on competition, it can direct the parties, it shall direct the parties to the said combination to publish details of the combination within 10 working days of such direction. So such direction has to be made in the manner which is prescribed by the commission, and after this maybe some information is received by the commission, and commission may come to the conclusion whether it should approve this proposed deal or not. So in this module we have discussed about the recent decisions which are taken up by the commission, the issues and challenges which are faced by the commission, and we have focused our studies only to in respect to the Competition Commission's working over here. We have not gone into details of the foreign jurisdictions. So I hope that you would be in a better position to understand the recent decisions of the commission and its challenges and issues, and we think that the commission will be doing a great work ahead. Thank you very much.